As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
Islam Moors.
My nationality is Moorish.
Hey, can you call up Newton Hensley Bay?
Mr. Bay, why are you not here today?
The schools and everything are closed today, so I ain't have no babysitters or anything at the last moment.
All right. Well, you do have some motions, and you also have a sentencing date, but I need you in person for this today. All right. You gonna be able to get over here later this morning?
I'll try to be on my route right now, Islam.
7 hours later.
We call the case of People v. Milton Hensley Jr. This is case number 23S18766FH. The defendant is present in person.
I do object. Relation is Newton Hensley Bay.
So two things here that are odd. Go. There. So this bond, so today it looks like we just have his motions today. We don't have a sentencing, so we don't have a PSI completed then.
Correct. We didn't I'm still waiting for the referral from the prosecutor's office, so I don't even have a date yet. But he did come to the office completely.
Okay. All right. So Mr. Hensley, then I thought we had a sentencing date today. So it's just your motion today. So just like I have every time you're here, I got to go through these questions with you. All right. And I want to make sure we cover them. Yeah, go ahead.
My Honor, my name is Milton Hensley Bay.
This dude just called the judge my honor. Now he's not the first Moorish sovereign citizen that I heard address a judge by my honor. What is that about?
Yeah, I tried to remember that, Hensley Bay. All right, go ahead.
And I come before this honorable court today to respectfully address a matter of significant importance related to the case at hand. I hope to present this statement with clarity and transparency. On the 8th of January 2024, my honor rendered a judgment following the trial proceeding in this matter. Subsequent to the judgment, I, Milton Hensley Bay, filed an appeal with the Michigan Court of Appeals. The appeal has been accepted and is bears a claim of appeal number 369382. I am compelled to inform this court that I am impelled to inform this court that in the light of ongoing appeal process, I find it necessary to request a stay of the proceeding in this court. The decision of the Michigan Court of Appeal will likely have a profound impact on the direction and resolution of this case. Furthermore, Your Honor, I must express that during the trial, my request for a continuance was denied, hindering my ability to adequately prepare for the proceeding. Thus, compiled with my current indigent status, present substantial challenges, I am unable to afford the court the costs associated with obtaining additional transcripts, filing experiences, and even basic living costs as I navigate through this appellate process.
First and foremost, dude, you are not indigenous. Secondly, if you can't afford the cost to get further transcripts, get a freaking job.
In consideration of my indigent status, I respectfully request that the court waive the bond option or any bond requirement in this case.
Not gonna happen. No, not gonna happen.
The financial constraint I've made, the financial constraints I face make it impractical for me to meet the financial obligation associated with posting a bond. Waiving the bond requirement would ensure that I can effectively participate in the ongoing legal process despite my financial limitation. I humbly move to this court to enter in order to stay the proceeding in consideration of the pending appeal with the Michigan Court of Appeals. My Honor, I overstand and comprehend the gravity of this request and assure that the courtroom that it is made in the interest of justice and the fair adjudication of my case. I am grateful for the court's attention to this matter, and I am prepared to provide any additional information or clarification deemed necessary by the court without self-incrimination. Thank you for your consideration, Your Honor. Respectfully, Milton Hensley Bay.
All right, so Mr. Hensley Bay, I do have to ask these questions again, so they're gonna sound familiar to you. So you've got this motion before the court scheduled today. You do understand that you have a right to have the assistance of an attorney at any stage of the proceedings. This is another stage of the proceedings. Sir, are you waiving your right to have an attorney? You continue to want to represent yourself, or would you like the court to appoint an attorney?
My Honor, this man has no other choice but to represent himself. If he decides to go with a lawyer, he will be in dishonor, and his own Moorish people will no longer accept him. So he is stuck, even though he can't even afford to do anything to help his case. He's just a lost cause.
I'll continue to represent myself.
Very good. And then you understand that if you can't afford a lawyer, the court could appoint one for you. Would you like the court to do that?
No.
Okay. You understand that the charges that have been brought against you and now that you've been convicted of, those are serious charges. They, again, are the charges of, let me pull the information here. All right, count one is carrying a concealed weapon. That's a 5-year felony under a $2,500 fine with mandatory forfeiture of the weapon or device. Count two is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony under a $2,000 fine. A consecutive sentence can be imposed if the assault was committed in a place of confinement. And finally, count three is felony firearm, which is a 2-year felony. However, it's 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, along with mandatory weapon forfeiture of the weapon or device.
So this Moorish Sovereign Citizen has serious weapons charges. He seems, I guess, to be a violent criminal, and he is playing Russian roulette with his own freedom by deciding to represent himself. I just don't even understand these people. This is the stupidest decision you can possibly make.
So again, do you understand the nature of those charges and the maximum penalties, sir?
I comprehend.
All right. And as it relates to count three, that's worth some, I guess, a special acknowledgement. We've talked about this previously, but that charge by itself requires the court to sentence you to 2 years in prison, which you would have to serve before you would begin to serve any sentence on counts 1 and 2. Do you understand that?
Comprehend.
And knowing that, you still wish to go forward representing yourself?
I represent myself. Yes.
Very good, sir. Do you understand that there's risk of representing yourself?
I do not understand.
You understand that there's risk of representing yourself because the other side is represented by attorneys, and the court will be required, as I have throughout the proceedings, to hold you to the same standard as an attorney, and the court couldn't give you any special consideration or assistance, if you will, with your motions or defense or anything of that nature. In other words, I have to treat you the very same that I would the other side, and they're represented by attorney. Do you understand that?
Hernan versus Kane said you can't treat me as a jurist because I'm not one.
All right, so we did go through that. You did raise that motion earlier. Court has a different interpretation of that case and what it meant as it relates to pleadings and not actual motions or trials. But do you understand, though, that you could be at a risk of by representing yourself, and that you are not going to have the training, the experience, or the education that the other side does? Do you understand that?
I comprehend.
Okay. Do you understand that I have to require you to follow all the rules and the same requirements that apply to lawyers in this courtroom? You understand that?
I don't understand that.
Okay, so I just went through this. Do you want to represent yourself? The court has to treat you the same as the attorneys. I can't give you any special help or relax rules or something like that simply because you're representing yourself. Do you understand?
I comprehend.
Very good. That's a long way of the court saying I can't give you any special treatment if you want to represent yourself. Do you understand that? Okay. Would you like the opportunity to either hire an attorney or just talk to a court-appointed attorney before we keep proceeding today?
No, we're not.
So we know this Moorish Sovereign Citizen isn't going to hire an attorney because he just admitted that he didn't have any money, and it's probably because he doesn't have a job. But as the judge stated, he can go with a court-appointed attorney, which is free, and he is denying that. I just don't understand the logic with these people. You are about to go up against lawyers that do this for a living, and your freedom is on the line, and you want to represent yourself. This just makes no sense.
And then do you agree, if we go forward with your motion today, that you'll follow all the same rules that the attorneys and anybody else appearing in this courtroom are going to be subject to? Okay. Mr. Butler, do you have any questions regarding his waiver to counsel?
No, thank you.
All right, you believe the court's complied with MCR 6.005?
I do.
All right. So as far as the court is concerned, Mr. Hensley Bay has represented himself from day one in this case. The court has tried to run through all of the questions that have been provided by SCAO to trial courts as sort of guidance, if you will, for those representing themselves and wishing to represent themselves. Mr. Hensley Bay has been consistent in his desire, his right, if you will, to represent himself. I find that remains the case today. Again, the court asking these same questions multiple times of him. And when we do this, I don't mean to insult Mr. Hensley Bay's intelligence. It's just something the court is required to do. And it might, from his perspective, seem like, why do you keep asking me these same questions? I want to represent myself. I have a right to do that. And you're correct, but we do need to do this each time, at least this court's interpretation, each time that you appear, because you certainly have a right to change your mind too. You want to hire an attorney or ask for a court-appointed attorney, we can do that also, and then delay the proceeding until you retain or have a court-appointed counsel appointed. All right, so I do find that your waiver today, again, is knowing, intelligently, and voluntarily made. I would characterize it as unequivocal. Again, Mr. Hensley Bay has been steadfast in his desire to represent himself. I believe the court has, and Mr. Hensley Bay has also acknowledged the dangers of self-representation, that he'd be held, in essence, to the same standard as anybody else, court rules, rules of evidence, those types of things. And therefore, the court will then allow Mr. Hensley Bay then to proceed today. He has a motion before the court to stay the proceedings pending appellate decision. Now, this is one of those things, again, comes up when folks in representing themselves. He has filed his motion, scheduled it on for today, it appears. But he's also filed a claim of appeal. At least in this court's opinion, that claim of appeal is premature and that Mr. Hensley Bay simply has not been sentenced yet. So to the extent the court has one here in front of me, a claim of appeal that appears to bear his signature and was dated January 16th, that's not something the court would consider or can consider, at least in the court's opinion, because he's not yet been sentenced. Now, this is something he certainly can file post-sentencing, but that leaves us then today to the motion that was filed, which is simply a motion to stay the trial court proceedings.
Now, the mere fact that this Moorish Sovereign Citizen has already filed an appeal and he hasn't even been sentenced yet is evidence that he has no idea what he's doing, and he needs to get an attorney because he is clearly going to lose his freedom if he doesn't.
Mr. Hensley Bay, is there anything you want to state this morning in support of your motion to stay the proceedings, which would mean, in essence, the sentencing date that is, I don't know that we have a date yet, do we?
Yeah.
That will occur at some point in the future.
Only thing I have to add, John, is what I just read to you.
Okay.
A motion to stay, granted that everything been done, case is over with the Court of Appeals. They gave me a number and everything, so the case is active. And I just ask that you, give me a motion to stay where we can get everything in order, because I also paid for the transcripts, and I was told it'd take maybe 3 months before I can get them. You know, so I just, rush to the court to give me that time, render that time to get these things in order.
All right, then Mr. Butler, what's the people's position on Mr. Hensley Bay's motion to stay?
So, Your Honor, I did receive a motion, I suppose, from the defendant. It looks like sometime in maybe January. And it's titled "Motion to Stay Court Proceedings Pending Appellate Decision," and it is 3 pages in length. Last night, I received an email about 7:25 p.m. from someone other than the defendant, Curtis Sean Joseph Bay, sending an email. It appears on behalf of the defendant with an amended motion for stay of execution pending appeal. Did that get filed with the court?
I've not seen it, no.
Okay. So I suppose I won't address that. Then just looking at what
it was filed on the 22nd.
So, but Mr. Hensley, that raises a different question I'm concerned about. So you've consistently represented that you want to represent yourself. This would sound like this is a third individual that's filing something on your behalf.
No.
Is that correct?
Yes.
Okay. Who's the third individual?
You told this Curtis Bay.
Curtis what?
Bay. Sean Bay. Yes.
Curtis Bay. So is that a relative of yours or something?
Yes.
Okay. Is he an attorney?
No, he's not an attorney, Your Honor. He's just another Moorish Sovereign Citizen trying to help his friend, which further indicates that this man clearly doesn't know what he is doing. If he's trying to represent himself, then that would mean no one else can file anything on his behalf. But he clearly does not understand that, which is why he needs an actual lawyer.
You have information.
All right, but he's not an attorney.
That's my knowledge, no.
All right. So, because it's not been filed with the court, certainly Mr. Butler has raised it, court would not consider that today.
No, it's been filed. It was filed on the 22nd.
I don't have that. We'll have it. Hold on. We'll have Mr. Geiger, our clerk, is going to search for that. But even if it was filed on your behalf, if it's not an attorney, and you've indicated to the court you want to represent yourself, courts can't consider that anyway. All right, because a non-attorney cannot represent you. You can represent yourself, or you can have an attorney represent you, but you can't have a non-attorney that's represent.
According to my nationality, Moorish American, we have counsel, and that's how we do with counsel.
Yeah, well, I'm not aware of a court rule that would allow the court to have a non-attorney practice law. So that's a bridge we can cross, I guess, if and when we get it. But then, Mr. Butler, I would like you to address Mr. Hensley Bay's motion to stay the proceeding.
Thank you. Then just focusing then on the January 10th motion that was filed. The defendant doesn't give any rational basis for the stay of proceedings. There's no citations. There's nothing, no court rule, case law, nothing like that cited. What the defendant does cite is Rule 6.004 in regard to speedy trials, which is wholly applicable to this case altogether. The defendant is not in custody. He's not an inmate, a prison inmate. It just does not apply. And so with that, we would ask Your Honor to deny the defendant's motion based on lack of merit.
All right, Mr. Hensley Bay, I am going to deny the motion for stay. Mr. Butler's correct. In reviewing what you have filed here, and it's a 3-page document. The third page is just a signature page, it looks like. There is no grounds that has been cited that the court could rely on that would make sense for a stay. Now, you certainly still have a right, I'm going to deny that, but you certainly still have a right. You can file a request to stay the proceedings in the circuit, in the appellate court. There is a mechanism to do that where you could then also ask for an expedited review of the same. But I don't know that I'm aware of that, other than you're indicating you have, and you have filed this thing called claim of appeal, which again this court does not believe is appropriate because you've not yet been sentenced. In essence, you're I think what you want to do is you want to have a adjournment of this, or stay of the proceedings, if you will, to have the court review something that is not yet right, which is the outcome of your trial. And it's not yet right because you've not yet been sentenced. So I'm going to deny that motion. I'm going to ask Mr. Butler to prepare an order that says your motion to stay the proceeding is denied. Now, if you do file something with the Court of Appeals and they grant your request for a stay, they would inform the trial court that the proceedings have been stayed.
Can I get that?
And then we would go from there. What's that? All right, so just for the record, so the clerk has just handed to the court a filing that occurred yesterday. It is titled Amended Motion for Stay of Execution Pending Appeal Bond to be Waived. It's 1, 2, 3 pages in length. That is filed by Milton Hensley Bay, and that appears to be were these other pages attached? Exhibit for a motion to stay.
I believe that.
Okay, so then there's a third page that says exhibit for a motion to stay, case information, case header, case number, Court of Appeals 369382. Second page is citing the, looks like the parties, Allegheny County Prosecutor, and then Hensley, Milton, Joseph. 11604, it's or 24, incomplete filing, order appealed from trial court on the circuit court, and then my name is a trial judge. Motion waived, transcript was requested, defective holding file letter. All right, so that looks like, I guess it could be, it's a copy. This was filed with the clerk's office, maybe what Mr. Hensley Bay has been referring to, he had something up a moment ago. So it looks like maybe he did file something with the Court of Appeals. So if you did, sir, this court certainly will take direction from the Court of Appeals if they give us some sort of indication that they have stayed these proceedings, or they will give you additional direction along with the court, what they are looking at as it relates to this filing, whether they have accepted it, rejected it as being incomplete, or something of those.
But they said they accepted it when they give me the number. That number you just read out there,
Yeah.
369.
Yeah.
382.
Mhm.
That was the number that they when they give it to me,
Right.
the number they accepted.
Yeah.
So that's why I came when they gave me the information. That's why I presented the information to y'all yesterday. And it was
Okay.
also presented to me.
So that's been filed with the clerk's office, but it doesn't change this court's opinion about the motion that was properly before the court today, which was a motion to stay the proceedings. I'm going to deny that. I'm going to ask the prosecutor to prepare an order that indicates something so I can sign it. And then you certainly can get a copy of it from the clerk's office so that we're all on the same page. Now, again, if this, meaning this filing that I was just handed, results in some sort of direction from the Court of Appeals that your case has stayed, meaning the sentencing date, that we're going to stay the proceedings and the only thing left would be a sentencing date, then certainly the court would follow that directive. But right now, I'm denying your motion to stay the proceedings. And then Ms. Bond, can you give us an update then? I have Mr. Hensley Bay here. What's the status of that PSI?
I have yet to receive a referral from the prosecutor's office, so we haven't even begun the process yet.
Oh, so I assume he checked in with you though after his trial date?
Yes,
Okay.
he did come following the trial and completed his packet. So
All
I
right.
do have all that.
So you'll be contacting him in the future to then complete a
Yes,
PSI?
correct. Yep.
All right. Then, Mr. Butler, you'll prepare the order denying his motion here today.
Yes.
All right. Then, Mr. Hensley Bay, that just means that we'll stay on track for a sentencing day. I can't tell you when that will be yet. They're going to contact me, probation will contact you to begin, or I guess not to begin, to continue is the way I would put it, that process of completing the pre-sentence report. As I mentioned to you before, once that's completed, then you'll get a copy of it. You'll have a chance to check it for accuracy so you can let the court know when we come back for sentencing if there's any information in the report that is inaccurate, then we can get those corrections made so we have accurate information on which to base sentencing. So,
can you also give me a ruling on, because when I also asked the court, because of my financial situation, can you waive some of the transcript fees and the filing fees?
so it was my understanding that the court already signed a waiver, didn't they? I thought you were given the waiver, a waiver. Yes?
For court filings.
Oh, for court filings. Okay, for transcripts. So maybe that was in here. I thought. Let's look at that. Let's see.
I think Selena was holding on to it.
Who was?
Selena.
Oh, well, maybe she has it. We
Grab
can
it.
talk about it now. Oh, here. Let's see. All right. So this looks like this was filed on January 10th. All right. So the court does have it. So Mr. Hensley Bay, you did file a fee waiver request. You indicate you receive SSI.
How interesting. A Moorish sovereign citizen who believes this country doesn't have jurisdiction and all that other crap is getting SSI, which is set up from the very government that he despises. These people are complete hypocrites, and this man right here is a complete idiot, and he is clearly going to lose this case and wind up behind bars.
And you didn't fill out any additional information as it relates to income. So there's a box 3, your household income, the number of people in your household, your source of income. The court did review this on the 11th. It looks like at that time, the court denied it because I didn't have all the information. Income information had not been provided. So if you want to complete this, I certainly would review it again today. So it's that box 3 if you want to approach. Thank you. All right, thank you, sir. So for the record, Mr. Hensley Bay has returned this to the court. So we have a gross income of $1,900. Is that every week or every 2 weeks or a month?
No, that's once a month.
Once a month, all right.
Sure.
And the source of the income is the SSI.
SSDI.
Mr. Hensley Bay, it's curious to the court. When I'm looking at my notes from the trial, you indicate you're on this supplemental income, Social Security, if you will. I guess not supplemental, Social Security. But the testimony from both the 404B witness from the prior incident you had in Grand Rapids and then this incident, if I recall, you were driving a newer BMW. You might have been driving a Mercedes with the incident in.
And it was my vehicle.
Grand Rapids. Whose vehicle is that?
It's for Sarah.
What's that?
The BMW is for Sarah.
Okay. Did you have a different sort of income back then? No.
The Range Rover, the Range Rover was 2011. Automatic vehicle. Somebody I knew, somebody was affiliated with, kind of helped me.
Okay. And then the other thing that's troubling to the court is I'm handed this and you've finished filling it out. I think my administrator indicated you came in and paid cash for your transcript already. Is that accurate?
Yes.
Okay. So is the cash part of your $1,900 a month?
Man, I'm depleted. That's man. I'm 50 years old, so everything I had saved, man, that's what it was.
All right. So here's, I guess, my question. I don't know this. Do you know, was that the amount that was provided by Mr. Hensley Bay? Is that the full amount of his transcript, or is
Estimated full amount.
that's estimated full amount?
Mhm.
All right. Well, here's the issue with that, Mr. Hensley Bay. My understanding of the court rule is the fact that you are receiving Social Security makes you eligible for a waiver. So I'm going to sign your waiver. I'm going to redate it today. I'm going to check the appropriate box, cross these out. Just going to note Social Security. It would be the 23rd, 2024. And then I'm going to check cash to be returned. Now, if you want to use that to hire an attorney for your sentencing date, you're welcome to do that. You're welcome to continue to represent yourself. Do you have any questions about anything?
Just gratitude for what you did.
All right, so I'm going to give this to my court staff, and I'm going to ask you to step over to the clerk's office, or not clerk, to the circuit court office, which is right outside this door. You can talk to my administrator. What I'd like you to do is I'm going to have her draw up a piece of paper. You both can stand there and count the cash, and then you'll acknowledge that I don't know what the amount was, but whatever you gave to the court is being returned to you. I'd ask that you sign and acknowledge that. All right.
Okay, gratitude.
Okay. They're going to contact you, meaning probation, to finish the PSI, and then once that's done, we'll give you a new sentencing date. Okay. I apologize. I thought this was the sentencing date. You do need to be in person for the sentencing date. If this was just a motion, had I known that, I would have let you appear remotely. But I thought you were here for sentencing. All right. So I know that you appear for your court date, so I'm not concerned about that. Mr. Butler, anything else?
No.
Okay, you're all set today, Mr. Anthony.
You have a order for me?
Sure.
You have a order for me? To deny the motion?
All right.
No, I don't know. My option to print it, prepare to print it.
I'm gonna wait for it, then bring it to the federal court.
Okay, yeah, that's fine.
Gratitude.
All right, and then we're going to continue with our docket. So you're all set
Okay,
today.
gratitude.
You're free to wait. Mr. Butler, what else?